Right. It is 9:01, and I think we should start. So good morning to everyone. A very warm welcome to this webinar to connect the dots between due diligence, sustainability reporting, and if and how that relates to public procurement. My name is Pauline Göthberg. I work as a national coordinator for the Swedish region's work on sustainable public procurement. This webinar is co-organized by the Nordic regions and enact sustainable strategies. And we are very pleased to see both so many people here today, both suppliers, contracting authorities, and other stakeholders. Before we continue, I would like to briefly introduce my Nordic colleagues who are part of this cooperation. And I will ask each of you to just mention your name and organization that you represent. Maybe perhaps we could start with you, Olivia. Are you there with us? Otherwise, we might jump over the Nordic Sea and to Elina.
I think we have to
light the microphone. Okay, so I am not the perfect organizer of webinars, so I might have forgotten that I will give the floor to some of you.
I think I can arrange that.
Okay, perfect.
Hi, everyone. Thank you. Good morning. The camera is also blocked, so you cannot see me, but it's okay. Don't worry. Here it is.
Now we have access.
Now we have access. Yes, hi. My name is Olivia. I work at Central Denmark region, and together with two other colleagues, I represent Denmark in our Nordic cooperation.
Thank you so much, Olivia. I'm sorry for the technicalities here.
Okay.
Elina, do we have Finland with us? Maybe we can start with Merete from Norway.
I just need to find them to grant them some.
Okay, I'm sorry. Yeah, sorry, I put you on the spot, Selina.
No. Okay, let's see.
You will soon have the floor.
All right, Merete, I think we can hear and see
Yes,
you.
now I could get the microphone. Okay, thank you very much. Merete Sunde, I'm working for Norwegian Hospital Purchasing Trust. We are doing the purchasing for the tenders for all Norwegian hospitals.
Thank you, Merete.
Very much with both due diligence and environmental and climate issues for the hospital sector in Norway.
Thank you so much, Merete.
Thank you.
Have we found Elina in there?
Yes, and now we should be able to hear Elina.
Yay! Elina, go ahead. Are you there?
We can see you, Elina, but we can't hear you.
Maybe I can do the introduction for you. Elina worked for the...
Now.
Oh, great.
Can you hear me?
Yes.
Yeah.
Now we can hear you.
Yeah, technical issues. So, Elina Kukkasjärvi from Helsinki University Hospital from Finland. I work as a development manager here. Good morning, everybody.
Thank you, everyone. I'm really sorry about the technical issues. As I said, this is not my expertise in organizing webinars. Anyhow, just as a background, in 2023, all the Nordic regions signed a letter of intent to work together, and our aim is to really strengthen sustainable healthcare procurement and move towards greater alignment in the Nordic regions. Just a few practicalities before we start. We are recording today's webinar so that it can be shared afterwards. Please save your questions for the end. You're welcome to post them in the chat, but also you can also ask your question during our Q&As at the end of this session. So enough of the housekeeping. So the reason why we are organizing this webinar now is that there are several important developments at the EU level, such as the Omnibus 1 package on corporate sustainability reporting and due diligence. And today we will focus on what these changes mean in practice, mainly for companies, our suppliers, but also if they have any implications for public buyers using contractual requirements on due diligence. And we're very pleased to co-organize this webinar with Sandra Atler from Enact. Sandra will start the seminar and help us navigate this, what you could call like a EU acronym jungle, and what it means in practice for companies. And then we will discuss what this may mean for sustainable public procurement. Before I hand over to Sandra, I would like to briefly introduce her. Sandra is the director of the Human Rights and Business Practice Group and senior advisor at Enact. Sandra is a human rights lawyer, and she was until recently a member of the EFRAG's Sustainability Reporting Technical Expert Group. This is, for those who doesn't know, the advisory body that has been central in developing the European Sustainability Reporting Standard. And I also know that you supported Professor John Ruggie and his team in the work that led up to the UN Guiding Principles, you know, the framework on which human rights due diligence is built. So Sandra, we are very pleased to co-organize this webinar with you, and I give the floor to you.
Thank you, Pauline. Great to be here and to be talking with all of you today. So I think together with Pauline, I would very much welcome you to ask any questions in the chat. So feel free to just ask them and we will catch them when we can. Okay, hope technology is with us now. Okay, Pauline, you're going to have to be my check-in if things are not working.
It is working perfectly.
Okay, fantastic. All right, so in kind of getting to this webinar with Pauline, we talked about the main kind of reasoning is that given all the legislation with that is taking place within the EU and all the revisions and updates and so forth, of course, the public procurement has always been a bit of a special animal, right? A little bit ahead of things often, but now there has also been limitations on the directives at the EU level. So that is what we're going to talk about today. I'm both going to try to give you an update, but also the limitations in terms of asking for information, and then hopefully we'll discuss with the help of you in the audience as well what that can mean for public procurement. So that's kind of the scope of what we hope to do. Okay. So, yeah, maybe just briefly about Enact. We are a consultancy. We are rather niched on due diligence and reporting. So really kind of the space that we're talking about today. We do mostly due diligence. We also do impact assessments, audits, of course. We're a small team of 20 consultants, but we also are supported by consultants and associates across the world. Okay, so Omnibus, I am pretty sure that all of you might have heard about the Omnibus. So as Pauline said, the original intention, if you look at the EU kind of website, the way that they summarize the goal is to simplify, making both due diligence and reporting easier to implement, and also to, again, simplify and strengthen their different type of regulations and how they operate. So if you look up Omnibus, it actually is a concept that is used for EU legislation when there is a need to harmonize concepts and ideas and principles. So because they kind of are, spread out. And that is definitely something that there is and has been observed a need for within this space. And of course, as we know, there isn't just the due diligence of the directive. It's not just the reporting directive, it's also additional legislations that are specialized in certain areas or focusing on certain topics that also rely on the disclosure requirements of the Corporate Sustainability Reporting Directive and the Due Diligence Directive. So one can argue that these two legislations that we're going to talk about now are kind of the motherships for so many other legislations, right? Like deforestation, you have different type of minerals and metals, you have conflict minerals, you have forced labor regulation that's coming, you have CBAM, you have all the sustainability legislation. I think it's amounting up to 12 regulations at the EU level at least. So these have to harmonize and work together. So that was the objective. So we're going to just briefly take a look at CSRD. And for those of you who feel like, okay, this is the acronym jungle, just let us know. But CSRD, Corporate Sustainability Reporting Directive, Omnibus, Simplified. We're going to kind of look at only what happened after thereafter. Okay, so we're going to start with that, and then we're going to look at the due diligence directive and what has happened with that. And then we're going to look at a timeline. Okay, so the Corporate Sustainability Reporting Directive is the overarching directive that is then delegated by the Commission into reporting standards through delegated acts, and that is what I was part of developing, as Pauline mentioned, at EFRAG, developing the reporting standards that are actually implementable for companies, right? So the Corporate Sustainability Directive that is towards states about what they have to legislate on. So the directive has been narrowed now we have companies above 1,000 employees and turnover of 450 million. Listed SMEs are removed, financial holding companies are exempted. There are certain phase-in and transition exemptions that have been pushed or extended or become more generous. So there's a transition exemption for certain wave 1 companies, right, during 25-26. And there's a possibility to expand and reshape these both directives in the future. The ESRS, the reporting standards, have been simplified, and they have been proposed by EFRAG, handed over to the Commission, and the public feedback consultation just closed on the 3rd of June. And so now the Commission is reworking both the simplified, or looking at the inputs, simplifying the ESRSs more or less probably in line with what we suggested from EFRAG, and also VSME, which we're going to look at in a moment. Another lovely acronym. Okay, so that's all anticipated will come into force, or at least will come into the EU force, and then of course there'll have to be trickle-down effects, right? Because states will then have to go home, so to speak, and transpose this into their domestic laws. So all of the countries on the EU level that have been legislating in line with the Corporate Sustainability Directive will now, after this is adopted, once it has been adopted by the Commission, have to update in line with these changes or amendments to the Corporate Sustainability Reporting Directive. So it will take some time before this all trickles down to companies in force and the states. We're going to come to that with a timeline at the end. Okay, and then there's this thing called value chain cap. So just want to go through what that is. The idea of the value chain cap, and it's an interesting term, but let's just accept that it's called value chain cap. The cap is essentially to protect companies that are outside of the scope of the CSRD, so below 1,000 employees. So the idea is that, and they are actually now called the protected companies or undertakings, apologies. And the idea is to not overburden small and medium-sized companies with requests for information and communication about disclosures now that we have this legislation coming in, right? So that's the core idea of the value chain cap. And what this means is that you are not allowed to ask companies with below 1,000 employees for information beyond the voluntary reporting standard that is based on the VSME. And what on earth is the VSME? We're going to come to that. So just bear with me if you feel it's a bit confusing and you're not super familiar with all these concepts. VSME is the voluntary standard for small and medium-sized enterprises. So we can just say it's the vehicle for small and medium-sized enterprises for voluntary disclosures reporting. But in the context of CSRD, so all the companies that are above 1,000 and that are part of or that are in scope for CSRD, you're not allowed to ask for information unless it is contained in the VSME, right? So the content is limited by the VSME. The idea is that the small companies have a statutory right to refuse, to say, no, that's not, that's not, no, I'm going to refuse to answer that. And this is now the important component. So this applies to sustainability reporting. It does not apply to due diligence or risk management information requests, right? So this is for purposes of reporting. The voluntary reporting standard is expected to become, again, a delegated act by mid-2026. So again, becoming mandated by legislation from the EU level. Okay, so let's have a look at the VSME, and this is how it has been put out to the public for the consultation. So let's have a look at the content. So it's basically structured around two modules. So one is the basic module and one is the comprehensive module. It contains information requests or information that you have to provide essentially. So if you are following the VSME, the small and medium-sized voluntary standard, the areas that you have to disclose on are essentially some kind of generic things that have to do with practices, policies, initiatives. And then you have basic modules around environmental metrics and then social metrics and then governance. But as you can see, they are very, very limited. So emissions, you have pollution, biodiversity, water, resource. And then for social, it's even more limited. It's general characteristics. So what does your workforce setup look like? Health and safety, and then collective bargaining, remuneration, training. For governance, you have just one item. And for the comprehensive, you can see it builds on a little bit further, which is essentially following the same structure. So it does mirror to the higher level degree the headlines of the topical standards, environment, social governance. But as you can see, there's still a lot of topics that from, for example, a human rights perspective and a environmental topic are not here, right? So this is the scope. So this means that when you want to ask questions in your value chain, this is what you can ask for statutory purposes, right? So anything beyond this, you would have to then have another base for asking for. So any topics that you see are missing here, that are, more expensive. So for example, when it comes to more granular information requests, you would have to have additional reasoning for that. We'll come to that in a moment. Okay, so then let's have a look at CSDDD. So CSDDD, just to lay the baseline. So CSDDD, what is that? Corporate Sustainability Due Diligence Directive. And maybe just as a reminder as well, that the reasons to why these are directives is that they are not directly enforceable word by word, right? So directive means that each state in each EU member state has the possibility, and no, they actually don't have the possibility. They have to go home, so to speak, and transpose this legislation into the way that it works best for their legislation. So compare that with, for example, GDPR or forced labor regulation that will apply word by word in countries directly, right? So directive has more space and flexibility for implementing. And that is because the legislation structure looks so different. And as you can see, the type of legislations that we're talking about here are very broad, right? It's very, it encompasses lots of possibilities and areas for that are considered. So in terms of law, you have different areas of law that will be impacted by these amendments. So if we just summarize in a nutshell what the Corporate Sustainability Due Diligence Directive actually is, It is structured very much based on the international standards. Pauline mentioned that I was also involved in the development of the United Nations Guiding Principles on Business and Human Rights. And for those of you who are familiar with that, or the OECD guidelines, which of course, public procurement, you will be, you will recognize this. So essentially, it's built, and so is the reporting standard. It's built very much on the idea that you can say almost like 3 boxes, right? You have the policy integration, the embedding, so making it part of the company DNA. And then you have the management of the impacts, which is the due diligence cycle, at least the 4 steps. And then you have the engage, the remedy, and complaints process. You can of course put different things depending on which framework you're looking at in different boxes, but more or less this is what we're kind of talking about. So the obligation is not for zero harm in all of your value chains. The obligation is not that you have to pay compensation for every single harm that ever happens or every incident that happens. The obligation is to conduct due diligence of impacts and environment on and human rights. Sorry, of impacts on environment and human rights. So essentially, it's an obligation of means, right? So, and that obligation of means is what? Is to have a policy and to make sure that is integrated into the way that you do your business. It's to have a process that manages impacts, and that management is a cycle of identification, assessment, prioritizing based on severity and likelihood and other aspects, and then trying to prevent, mitigate, bring to an end through appropriate measures those impacts by basis of what you are capable of doing. So there's a reasonable and proportionality requirement there, or possibility, and then monitor and remediate as depending the degree to which you are involved in the harms. And then the engagement and listening is about making sure that you, so to speak, have, 2 ears and 1 mouth. So you listen, you proactively listen, right? You invite, you have stakeholder engagement channels. You have a complaints mechanism. So both outwards and inwards, you report and you transparently share information. When something happens, it's an opportunity to learn. There are plenty of spaces in both the legislation and the UN Guiding Principles kind of best practice development, that this should be an iterative process. So when something happens, you have the right to say, oh, wow, I didn't know this, if it wasn't reasonable that you should have known it, and thereby learn from it, right? So it's not, on the date of application of this legislation, you have to have everything in place. No, it's an iterative process, and you should be transparent about how you are going through that. Okay, so in the chain of activities, and that is, by the way, the new term that we have to learn in this context. So value chain is still used, and supply chain is still used in the reporting standard, but in the CSDDD we use chain of activities. And part of the reason to that, there are plenty of reasons, but part of the reason is that often we talk about value chain, we talk about enriching value to the product or service, right? But companies often have other type of contractual relationships or other type of relationships that do not necessarily add value to the particular product or service, but rather it's maybe someone is cleaning the floor of your HQ, or who is delivering food to your office, for example, things like that, right? So it's contractual and other type of relationships that are not just enriching the value of the product, but also as a company you are having. In terms of upstream, so in the supply chain, you have pretty much all the way from design to production. So manufacturing, production, refinements, etc. Own operations include subsidiaries, and then downstream focuses on distribution, storage, and transportation. So not the entire way to end use, but rather only the steps through which your business partners might be engaged in distribution, storage, transportation. So that's how the scope is limited. Okay, so what about the omnibus cuts to the CSDDD? So the CSDDD raised the thresholds up to 5,000 employees and 1.5 billion net turnover. So it's really just the big companies. And the reasoning is that the big companies will be the ones that are best placed to kind of put this wave into motion, if you will, right? So the idea is, and you see that in the directive as well, that you are cascading something through your value chains. So if the big ones start, there are going to be wave effects onto other business partners. Scope has been reduced by 70%, leaving only about 1,000 corporate groups in the EU. For non-EU companies, it is only focused on the turnover threshold that is based on the EU market activity. So the degree to which you are actually having that turnaround or turnover on the EU market activity. And just to give examples, and this is not by any means the kind of final numbers. We don't really have an estimate. We have an estimate by an NGO called SOMO Group. They have a database where you can search for country and different sectors. And so they base it on group level. So for Sweden, for example, they list 63 at the group level, but some of these groups contain more than one company, of course. So then you have more or less 83 companies, legal entities, depending. For Finland, it's 21, leading up to 25. I think for Denmark, it's 49 groups. And some more companies, but not like the same amount as for Norway. Norway, you have, I think it's 9 groups, but many, many more companies when you count the entire list. Okay. So, civil liability has been removed. So just to go through what the things were that beyond the scope amendments, what was changed in terms of the content. And civil liability is that essentially the possibility to go to court, right, and hold a company responsible for failing on due diligence. So essentially the idea is, yes, it's an obligation of means, but if you fail in your obligation of means, when there is a harm that has arisen where you have, or you should have known about the impact and you should have prevented it and it was possible and reasonable and proportionate, etc., and you still didn't do it, then the idea is that you can be held liable in court for torts towards the victims, right? So that's one of the core enforcement capabilities. An additional one is that we will have authorities that will supervise and scrutinize and incentivize companies to live up to this. But the civil liability is a core component, of course, of this legislation's design. And in the beginning, one of the things that was discussed was that there should be a harmonized liability regime to make sure that companies have one way of understanding how they can be held accountable. But the legislations look so vastly different in one country to the next, and therefore it was decided to remove the harmonized liability regime. Personally, I think it would have been simpler for companies to have one. It would have taken more time, more effort, but the reasoning was that it would take too much, or it would essentially be a very big impact on the type of work that the states would have to do in the transpositioning, and therefore it was removed. But in practice, it means that companies have to understand all the jurisdictions where they operate and how they can be held accountable. Stakeholders. So why does this matter? So who is a stakeholder? That is important because the directive tells you who you need to engage with in terms of the processes of your due diligence, right? So it doesn't mean that you cannot engage with stakeholders or consider the input and engagement with stakeholders that are no longer listed, but it was more broadly defined before, and the reason was that it wanted to be very inclusive, but it has now been more narrowed. So for example, consumers, civil society, human rights institutions are not explicitly mentioned. Doesn't mean you can't involve them, it just means that they're not explicitly mentioned. Monitoring, so to kind of have this, review of monitoring of your due diligence efforts. Previously, it was mandatory to do it every 12 months, and now it's reduced to every 5 years. This doesn't mean that you can just keep going for 5 years and not check how you're going. It means, of course, you have an ongoing obligation to conduct your due diligence if needed day by day if you're dealing with really high risks, but it means that the entire structure requirement to review is not as formalized. So this is sometimes misunderstood, and I think it's important to emphasize that the ongoing requirement to conduct ongoing due diligence is not removed, it's just more flexible to the company. Penalties that these authorities can impose, the maximum cap is reduced from 5% to 3% of global net turnover. And the idea is that it should be possible to be felt by the company if something is done wrong and you do not change that behavior, right? It's still quite high, I think, but it was lowered. Climate transition plans. So this is a bit strange, but there's still a requirement to report on transition plans if you have them, but there is no obligation to adopt and implement the plan. So that's, of course, a very big gap from the climate perspective. So timelines have been pushed by 1 year. So you have the transposition that needs to be done by July 2028. So that's the states have to go home and implement this. They've been given 1 more year. Company compliance is also pushed by 1 more year. Guidelines from the EU is expected by July 2027, although there are discussions about this, but this is what is now in place. Okay. Now, we talked about value chain cap for the reporting purposes. So in the similar fashion, the politicians decided to also kind of protect, or how, I don't want to use the word protect here, but maybe limit. So make efforts to limit information requests in CSDDD. So to mention that there's this requirement that when you are identifying your impact, you need to both have an kind of, let's say, I like the term horizontal versus vertical. So horizontal, that would be your identification, your mapping, your scoping, right? Like, this is my value chain. What are my big issues? What are my hotspots? What are my severe topics throughout my value chain? And then you need to go deeper at some of them, and that's then the assessment, right? So I think that might be a helpful way of looking at it. So scoping, or the identification. So this here, what they're trying to do is to help you understand how far-reaching do you need to be in terms of what you should have known, right? Because the due diligence is expected to be based on the idea of what you should have known, right? And what you're expected to do. So you should scope and do your risk assessment based on reasonably available information only. Companies have the flexibility to judge what is reasonably available. So that is giving more flexibility to what you should have known and how far you should go. You know, is it a Google search for company plus human rights abuse or environmental challenge, or is it that you have to go and purchase all these big subscriptions? No, it's supposed to not have to be that you have to buy a subscription, right? It's supposed to be that you can determine what is reasonably available. But of course, it's going to be very much up to what's available on your market and about your peers in terms of challenges that they face. As a general rule, companies should not request information from business partners. Again, this is to not overwhelm and kind of, paperwork from one place to the next. When it comes to in-depth assessments, the limitations have been made so it should be required in areas where adverse impacts are most likely and most severe. Information requests for in-depth assessments should be targeted, reasonable, and proportionate. So it means that, maybe not a list of 200 questions for everything you might ever think about, but rather based on your scoping. What is reasonable that this business partner needs to tell me for me to know and understand what is possible impacts and what I can do about them. And they should only be requested if it's necessary and cannot be obtained in any other way. No information requests are required where no likely or no severe risks were identified. So there is a bit of a circle here, of course, with what you have identified and what you need to dig deeper into. So this is the limitation of information requests in the CSDDD. I just want to say, I'll pull everything together and try to formulate some key takeaways before we go into talking about the implications for public procurement. But I just want to send us away also with this picture, because this is one of my favorite ones when it comes to CSDDD, not necessarily the picture, but the idea of what it actually presents us. So the CSDDD, we often talk about, compliance is a very low baseline threshold. But when it comes to compliance and the CSDDD and what it creates an expectation for companies to do, I would say it actually does not present a low minimum approach, but rather it prompts us to ask the question, and maybe this is a send away to the next conversation about implications for procurement. It pushes us to ask, what is it that I can do to effectively try to affect the impact, right? So now I think many companies, they just kind of send out self-assessment questionnaires, they do audits as a routine, and supplier visit and check the boxes. But here we're saying, both in terms of information requests, but also in terms of what we're asked to do once we know about the impacts, the CSDDD is essentially saying you need to look at what it is that you are, what it is that you're actually facing, what is the impact, and what can I do about it? Is an action plan actually going to help? We often get the comment here, we don't have audits here, we don't have impact assessments here, we don't have certifications here. No, that's because those are tools. So these are suggestions for things you might consider doing, depending on what you find will be the most important thing to do to actually have an impact on the impact, to affect the impact in the right direction. So an action plan, could that be the audit's action plan, the corrective action plan? Yes, it could be. If that is the effective way to control something with your supplier, if you know that health and safety measures are often helped by an audit corrective action plan, then yes, by all means, that can be it. But for example, forced labor, we know that's rarely helped by an action plan or a corrective action plan following a basic audit, right? So then you need to think about something else. Contracts, business plans, you as a buyer also need to consider what you can do to, is your purchasing practices, if you're pushing for top quality, lowest price, quick delivery, and then asking your supplier to deliver everything on time and bear the responsibility for zero harm, zero forced labor, zero child labor, etc., then of course purchasing practices are not considered, right? Because then you're kind of creating a perverse incentive for your supplier to actually tell you what the challenge is. And maybe this is a bit of a pain point for public procurement too, to consider the push on prices. Let's discuss that. Collaborating with others, like sometimes when you can, consider if adding pressure from others could help change practice, engaging with stakeholders, supporting small and medium-sized companies. The last two ones are marked in red because that's post factor, right? So when something has already happened, you might have to consider remediation. That is not as far-reaching in terms of what is expected maybe of the UNGPs. But when you are causing or jointly have caused a harm, you should consider proportionately to contribute to that. And then suspension might be the last resort. So you want to kind of hang on with your supplier as far as you can before you exit, if it's possible, if the harms are, possible to do that. So I wanted to anyway just put this into the picture as a toolbox rather than, formal requirements. Okay, and then the timeline, yes, and then I'll come to the takeaways. Okay, so just to say, where are we now? We are here. We have now ahead of us, as I mentioned, the simplified ESRS, so the reporting side, the VSME, the voluntary standard. They will be adopted as delegated acts. Hopefully or soon, the simplified ESRS will begin to apply, and this will formally, for companies in scope of the CSRD, then kick into effect for reports published in 2028. In July 27, we hope for the European Commission to have published its guidance on CSDDD, and then the transposition for states, and then company compliance in 29. Okay, and my final picture to sum up is going to be this one. Reporting and due diligence are two sides of the same coin. So essentially, think of them as that, because they follow the same logic and structure, but of course the purpose might be different. Under reporting, requesting information is limited by the value chain cap. Under EU due diligence regulation, information requests are only when it's kind of necessary. So it follows a similar structure and logic. However, and this is really important, this does not limit contractual freedoms, the ability to decline a business, right? So if you have, for example, your own ethical higher ambitions, you can still say, these are my own ethical ambitions. This is where I want to go as a company. And I will ask that my business partners also reflect these ambitions, right? And if they then decline or refuse using their statutory right to refuse information, you can still say, okay, well, then I will not do business with you, right? So you still have that possibility. Investigate concerns or conduct risk management. So it's not going to be you can't go out and investigate or assess when you have a particular concern over something in a particular place, and also for risk management. And that is very clear and stated also in the regulation that this should not stand in the way for due diligence purposes in terms of the reporting side. Generally, the aim is to ensure that companies act with intention. And I think you can discuss, of course, back and forth, this is good, is it bad, what are the pluses or what are the minuses? But generally, I think, it's a good refresher, I think, for all of us. We've been using audits for so many years and SAQs. So it's a good refresher for us to say, okay, what are we doing and what is the purpose, and are we achieving that with what we are doing? And with that, I will hand over with a question to you, Pauline. This is, of course, a lot, and we've talked about this in many spaces, I think. But what do you think? How will this affect public procurement for the Nordic countries? You've worked with this, so to some degree you were ahead of the curve. But how is this going to affect, as you see, in your view, your work?
Thanks, Sandra, and also thank you for a clear overview of these new EU developments. Yes, it's a very relevant question. First of all, as public buyers, I think we welcome this legislation. And we see also a value in creating this more level playing field in Europe when it comes to corporate due diligence. And I think we also fully agree with the objectives of kind of avoiding unnecessary administrative burden, disproportionate information request, and particularly, when it comes to smaller companies. And this is important for us as well, because a majority of our suppliers are SMEs. But at the same time, I think it raises an important question for us as public buyers, because if and how do these developments interact with the contractual requirements, due diligence requirements that we set and follow up in public procurement. So maybe the first point I would like to make is that, of course, CSRD and CSDDD are primarily the legislation for companies. They are not public procurement legislation. So as contracting authorities, we are governed by the EU Public Procurement Directive, and in our case, in Sweden, it's the Public Procurement, Swedish Public Procurement Act. And also under the public procurement law, proportionality is already a fundamental principle, and we need to be able to justify why requirements are relevant, proportionate, and also linked to the subject matter of the contract. So in the Swedish regions, we have included contractual requirements on due diligence since 2014. So this is not really something new work, and this also goes for my Nordic colleagues. We've been doing this for a long time. And our ambitions has always been to stay as close to the international frameworks as possible, the UN guiding principles and the OECD due diligence guidance. And this also helps us to avoid creating a kind of Nordic special solution, and instead, create more predictability for suppliers.
Right.
I would also like to emphasize that our work is risk-based. That means that we do not apply these due diligence requirements in all our procurement, in all our contracts. We apply them in prioritized categories where we have identified significant sustainability risks. And for the Swedish regions, for example, this covers 16 purchasing categories. You know, we got pharmaceuticals, textiles, medtech, ICT, instrument, foods, etc. But you know, just to say that you know, at the core of our contract clauses, the supplier must fulfill the contracts in accordance with the commitments in our supplier code of conduct, and to ensure compliance with the code, the supplier must have a due diligence process in place. So this is really the difference, I think, between the what and the how. So the outcome that we want to see, you know, we don't want child labor, etc. But how do we achieve that? Well, that is through the due diligence requirements, the how. So, and also, in addition to that, our contract clauses include reporting obligations for severe deviations, our right to monitor compliance, and I'll come back to that because here I think it's important, and also for the procedures for managing deviations from the requirements. And I think you said that suspension as a last resort. I think we also take very much a remedy first approach on this. But also, I mean, we do not only set requirements; they are important, but it's not the only thing. What is even more important is, of course, that we follow up on the requirements during the contract period. So contract clauses only have a value if they are monitored, discussed with suppliers, used as a basis for improvements where risks or deviations are identified. So the question we have maybe asked ourselves is there anything in the CSRD or CSDDD that would prevent us from, you know, setting or following up due diligence requirement in our contracts? And more specifically, could our requirements lead our direct suppliers to request information from their sub-suppliers in a way that maybe could conflict with the value chain cap under CSRD or the cap on information requests under the CSDDD? So our preliminary result is no. Not if the requirements are applied in a risk-based, proportionate, and purposeful way. I think there's a distinction here between the CSRD and the CSDDD, because as you described, CSRD and the ESRS are mainly about corporate sustainability reporting. So that is not really our main focus of interest. But the CSDDD is different because it concerns due diligence requirements for the very largest companies. And of course, some of them are in healthcare supply chains. You mentioned SOMO, you know, we haven't done the mapping, but, you know, for example, companies such as, you know, 3M, Abbott, Baxter, Philips, Siemens, Medtronic, they are relevant in Nordic healthcare procurement, and they are in scope. So some of the companies that may be subject to these new obligations are also direct suppliers to us. So what we have done is maybe to start to analyze our current contract clauses to understand, you know, whether such a cap on information could be relevant. So in the CSDDD context, and as you explained, it is maybe most relevant to look at the cap on information in the Article 8. You know, it's concerned the identification and assessment of actual and potential adverse impacts. And this is where companies covered by the CSDDD needs to understand where risks are most likely to occur. And I think, as you mentioned, you know, companies should not ask sub-suppliers for information just in case, you know, it has to be necessary for the risk assessment. And if the information cannot be obtained in any other way. But and also, however, I mean, if I understand it correctly, there are other provisions in here that does not put a limit on the due diligence measures, you know, as in Article 10 to prevent and mitigate, Article 11 on bringing adverse impacts to an end, or 12 on remediation. So our preliminary assessment is that most of our due diligence process requirements concern suppliers' own policies and processes, and therefore are not directly affected. So these are the policies, allocation of responsibility, risk assessment, corrective action plans, grievance mechanism, etc. So that's not mainly a concern. The areas where we need to be clear and requirements that reach maybe beyond our direct supplier's own organization and into the supply chain are the requirements on our transparency requirements. That is one. The other one is the possibility to follow up or carry out audits at subcontractors level. So these are the two areas I think we have identified as might affect. And just to explain, so the transparency requirements that we put into our contract means that suppliers, upon request, must report which sub-supplier and are used to fulfill the contract, so including legal name, physical addresses. So the transparency requirements are important because, without knowledge of the supply chain, it becomes very difficult to conduct meaningful risk assessment and follow-up. And also in today's geopolitical situation, it is also about building robust and resilient healthcare supply chain. If we do not know where critical products are manufactured, sites, etc., it becomes very hard to prevent and respond to disruptions, shortages, serious sustainability risks. So in high-risk health categories, public buyers may need information about where final manufacture takes place. And I think, we need to put closer attention to that. But this is not only a Swedish approach. I mean, we see similar elements in the contract clauses by our Nordic colleagues, especially in Norway and also beginning in Denmark. So just to be clear, that transparency is not about full traceability across all tiers in all contracts. It is a risk-based and is also proportionate. The other point and the other thing in our contract clause is the audits at subcontract level. This is the other area. So, I mean, it is legitimate for public buyers to require suppliers to cooperate in follow-up and seek to enable audits. But this should not be maybe interpreted as an absolute guarantee that a supplier can always secure access to every subcontractor's site. This is not what we mean. So rather, the supplier should be expected to use its leverage, seek to secure contractual access where possible, provide information, forms of verification, and also maybe in some cases, alternative sources of information may also be relevant. So, okay, so to just conclude, and this is a long answer to your question, where does it leave us? I think the new EU frameworks does not prevent due diligence requirements in public procurement contracts, but it also reminds us that our requirement must be risk-based, proportionate, and clearly linked to the contract performance. It is. I think you also show the timeline, and it's important to remember that this will not apply immediately. So we have until July 28th to transpose the directive, and then it will comply by July 29. So we still have time maybe to understand what this means in practice for public procurement. And we will, of course, take this into account when we do revise our contract clauses. And finally, I think from a Nordic maybe perspective, this also shows how important it is to coordinate our efforts to align our expectations and follow-up methods, so we can make it also more predictable for suppliers and avoid unnecessary duplication. Yeah, so long answer to your question.
Thanks, Pauline. I think this is exactly what we wanted to target in this session. So I think that was a very robust answer, and I'm super curious to hear also what people in the audience are thinking.
Yes, I do think we will open up for question, and because of my lack of technical expertise in organizing this, I think it will not be possible for people to speak up and ask. So I think we will see if there are any questions in the chat.
Yes. So far there is no questions, but please use the chats and
yes,
ask any questions. I mean, I think there are some quite interesting pieces of information here. Okay, here's a question. Shall I read it for you, Pauline?
Yes.
Oh, you used. Oh, there's a Q&A. Oh goodness, sorry about that.
Oh my goodness. Oh God, I'm learning.
Okay. Okay, there are some questions here. Okay, fine.
Okay,
So,
can you read it, Sandra?
yeah, so Signe asks, how do you assess the appropriate approach for companies navigating conflicts of law between CSDDD and, for example, Chinese regulations that significantly constrain the ability to conduct due diligence on Chinese suppliers?
Oh God,
Right.
yes. So that's another webinar, I think.
That's another webinar.
Do you want to start, Sandra?
Yeah, sure. I mean, I think that there has been some developments on constraints in that space, and I think on an overarching level, it is really up to the EU to provide that guidance on how to navigate core kind of geopolitical relationships in a way that doesn't leave EU companies in the situation of having to, pull in expensive legal advice to look at a situation that everyone else is also looking at. So I think at the moment, I know this is not probably the answer you want to hear, Signe, but we are very much following also what is happening. And yes, there is this very direct conflict of regulations. We're watching to see what happens. CSDDD doesn't apply yet. But of course, this is something that the EU guidance, both on CSDDD but also related regulations, would have to target. So I think this is crucial for the credibility of the entire EU project, that EU has the possibility to resolve this, because we rely on China for so much. I'm afraid I don't have a better answer to that. Olivia asks, I totally agree with what Pauline is saying, and I'm wondering if the value chain cap. Oh, sorry, Pauline, did you want to respond to the other one, the Signa's question?
Well, not really. I mean, we are super dependent on China, so of course this matters to us. I think I don't know, until we have any other directives or signals, we're going to continue as long as this is also proportionate and risk-based, but we cannot discriminate an entire country just because it's high risk. So I think we have to be very careful on how we do this. But, I think until business as usual, until otherwise, yeah.
Right. Thanks, Pauline. Okay, I'll read you the one from Olivia. Pauline, this one is for you. I totally agree with Pauline is saying, and I'm wondering if the value chain cap might risk to clash with the local contractual frameworks on due diligence in the long term.
Well, as I said, I don't think it does. I think, first of all, I think we have to be careful. It's super important that we are risk-based, it's proportionate, etc. The value chain cap, as I understand it, it only relates to CSRD. So this is not really in focus, but if it's constraints on the request for information, it's only, at least in our contracts, it's mainly related to two things, and maybe it's a matter of putting this more into our guidance and clarify this. And of course, we will have a look at those two paragraphs when we do revise our contract clauses. So, but at the moment, no, I don't think it's constrained.
But it's definitely, I agree with it. There's definitely this tension there that it's really good, and I think it's also very helpful that you have this guidance, Pauline, where I suppose this will be clarified. But it's important to keep watching and thinking about that, because I think clarity is going to be helpful. Okay, Niklas asks, this discussion raises important questions. Should procurers have a different set of requirements depending on if the supplier is SME or not? And is 1,000 employees a significant larger than definition? Sorry, less than 1,000 employees is significantly larger than the definition of SME 250 in Sweden. We've audited a lot of SMEs and larger companies, and there are no clear line that fulfillment is more difficult or easy depending on the size of company. Yes. Do you want to give a try, Pauline?
Well, I mean, from a public procurement perspective, I mean, we are following the equal treatment principle, which means that we cannot differentiate between big and small companies. We have to make the same requirements on all of them. So that's one thing. And in my experience, it's not only the big companies that can fulfill the due diligence requirements. I find sometimes that the smaller ones have bigger oversight of their supply chains. They have fewer sub-suppliers, etc. Sorry, I don't think maybe this is a reply to the question.
No, but I think it is, and I can try. Maybe this is on the regulations. So I've sat at EFRAG when we developed these standards, and Niklas, I totally agree with you, and I tried to keep my presentation rather focused on the content, but I totally agree. I think that the VSME, using VSME as a value chain cap makes no sense from a variety of perspectives. It is there now, so we have to look at it for what it is. But I at the discussion process of before it became, the VSME was never intended to be the value chain cap, and it was never intended that it should apply for up to 1,000. It was intended to be 250. So I think you are right. I don't think I agree with you. I don't think it's, you know, the size of the company doesn't necessarily depend on, or isn't necessarily the most crucial kind of factor. So, but that is where we are, and you know, that's what we have to work with, I suppose. But yes, it's a good observation, and that takes us to the end of the Q&A. But please let us hear. Okay, we have a few more in the chat, so I will navigate there. Okay, so the China one we talked about. What can companies do if tier 1 suppliers will not disclose sub-suppliers? Yes, great question, Susan. Pauline, I'll give that one to you.
Yay. Well, I will lean on to my Norwegian colleagues, because I think they have had many years of actually doing this. So in their tender documentation, in the process, I mean, the suppliers need to fill in the name and addresses for their final assembly, and they've been doing this for years. So this is not really an issue. So. I mean, I'm just trying to think about examples when it's been difficult to get the information. I mean, I think it's also related to one of the questions here about disclosing company-sensitive information. I mean, of course, yes, we work for public authorities, but you know, company-sensitive information is under secrecy, so we would not disclose that automatically in any way. So, so I think that is protected. Yeah. Yeah, I think, yeah, I'll stop there.
But yeah, I see. So that's not necessarily a deviation then from your
sorry, deviation from the contract clauses. Okay, not to disclose. Yeah, but I mean, it is in the requirements that they should at least the final assembly. So yes, in a way, it is a deviation if they are not providing this information. Yes.
Right. But, and also basic information that is covered by the VSME, right? So basic information about your supplier should be known to you. But of course, Susan, your point, I suppose, is whether, you know, sometimes it's sensitive that you cannot provide it for competing reasons or just confidentiality for a variety of reasons. But that's probably more public procurement type of question than to the regulations. Susan also asks, what is the recommended way of using AI in sustainability due diligence and risk assessments to speed up necessary information required? That's a good one. I mean, I can start maybe from the legislation perspective. I think, you know, the idea of what is reasonably available to a company is going to very much change. I mean, it already is, right? It's different now than it was 6 months ago. But I think at the point in time when CSDDD is effective, it's going to be much easier also to find information. So that is going to increase the bar for what you are expected to reasonably know about, right? So so using AI is also going to reduce the need to ask direct questions because you will have a lot of information compiled, I would assume. Pauline.
Yeah, and I think, you know, yes, I mean, AI will probably simplify the scoping exercise, you know, getting publicly available information, etc. On the other hand, I think we, as on the other side, like checking this risk assessment, for example, you know, to detect whether they have just been AI generated, because, you know, we say that the due diligence processes need to be implemented in the company, but if this is just an AI exercise, it is not really implemented. But I think it's new territory for us as well. So we're not there yet, but we do see examples when we can maybe suspect that this is AI generated replies rather than, you know, based on, well, this is, yeah.
Right. Yeah. Yeah, exactly. And you can also say, right, in the reverse, that that supplier responses to questions are also going to be generated. So it might be easier to find information, but it's also going to be easier to fabricate or produce information using the big LLM systems to, you know, facilitate that. So, okay, Sarah asks, do you consider that third-party certifications in combination with established control and verification systems can facilitate contracting authorities' efforts to monitor and verify compliance with contractor requirements? I think that one's for you.
I think that too. No, I mean, we're very positive to third-party certifications, these schemes. So yes, of course, and if you think about the resources that public authorities normally have in terms of, you know, doing checkups, it's much easier, of course, to have a certification. I think, but what we need to do to be is a bit careful to ensure that the certification actually covers the contract clauses that we do require. I mean, there are several very good verification schemes, etc., but there are also ones that do not cover social issues in our contract law. So, you know, we need to be very competent on what these certifications do and what they don't cover. So, yeah.
I think that's a great kind of reminder also, that, you know, it's about understanding the purpose and intention with what the reasons we're doing. So if it's certification, what are we trying to control with it? Okay, so Susan asks, yes, noted, we have a few more in this SAQ or in the questions. What is the recommended approach when companies need to understand full value chain, but tier 1 are reluctant to share information about sub-suppliers? Did we cover that, Pauline, already? Yeah, kind of did, right? Okay. And then we have one from Katarina, which is another thought. How are you planning to integrate the upcoming EU forced labor regulation into procurement processes, given that it will directly affect which products can be placed on the market?
Yes, well, I don't have a good answer for that. I mean, it is as I understand it, the custom and border authorities that are obliged to, you know, either confiscate or dispose of, etc. And those suppliers that are putting these products on the EU market. So I don't know whether this is kind of an information that goes to public authorities. So we are aware that this shipment has been stopped. I mean, this has been going on in the US for a long, long time, you know. But on the other hand, you know, what are our obligations? I mean, if we suspect forced labor in our supply chain, are we obliged to report to the Custom and Border authorities? You know, so I don't have a good questions, you know, answer, sorry, but more questions, I think.
I think that's absolutely right. And I think, I mean, the good answer to that, if I may also try, is I think that, you know, all the due diligence efforts that you are putting in, so the forced labor regulation doesn't focus on the company obligation to demonstrate due diligence, but they will remove, regardless of how much you knew and what you did and whether you remediated, if something is tainted with forced labor, a product, it will be removed, as you said, Pauline, it will be destroyed or kept or you know, removed from the market. But when it comes to, therefore, what can we do to prevent that from happening? That's when due diligence plays in. And that's when due diligence, in accordance with international standards, will serve the same purpose. So I think the best way for companies to prepare under public procurement is to have those processes in place and focus on forced labor. So if you want to kind of safe bet or stress test your processes, I would say take this time and focus on, you know, making sure that you have your protocols and your controls for forced labor. Stress test your due diligence on forced labor until we have the guidance material that the EU Commission has promised also now in June on the forced labor regulation. And maybe once we have that, maybe Pauline, that's another webinar. It's quite a big topic. But thanks for asking, Katarina.
Great. Do we have time for one more, or are we?
Yeah, sure. Let's do maybe the last one. We are 4 minutes into closing out. I think there was one more. Let's see. No, I think that was probably it.
Oh, right. Okay.
Yeah.
Great. Right. Well, thank you all for very good questions. And I think we are now approaching the end of this webinar. So first of all, I would like to warmly thank you, Sandra, for a very clear, useful presentation and for unfolding this complex EU new regulation. From a Nordic perspective, maybe we will continue working together to align the sustainability due diligence requirements. I would also like to thank all of you who joined today. We will send out the recorded session so you can use that. I think also we would be very, very grateful if you could take maybe a few minutes after this to respond to a short survey. It's 3 questions just to get your feedback on how we can plan our future activities. So from me, thank you for joining us today, and we look forward to continuing this dialogue.
And from me, thank you, of course. Thank you for hosting this, Pauline. Look forward to next steps.
Thank you so much, both of you, Pauline and Katrine. I really appreciate it. And Sandra, thank you.
Thank you.
Thanks a lot.